You guys, you covered a lot of ground there. Just in terms of tactics is one of the things you talked about. Can you switch to our computer, please? Okay, starting at frame 3286. Can you give the jury a little bit of background? What do you mean by tactical advantage here when you're talking, I guess, in this specific instance?
Really, in this type of context, we're talking about does the officer have more control of the individual than the individual has over the officer? In this case, the officer has a number of weapons, both bodily and other, available. It's fairly difficult for someone in the position of Mr. Lyoya to attack the officer in this position. So, officer has more control over him than he has of the officer. That's tactical advantage.
Now, in terms of tactical advantage, does that go into your imminent threat analysis then in terms of when you're trying to determine if a shooting was appropriate or inappropriate?
Yes.
And how does that factor in terms of imminence here?
So, again, when we're talking about imminent threat, even if someone has the ability to cause some type of harm, if they do not have the opportunity to do so, then there is no imminent threat of that particular harm. So if we go back to my hypothetical about someone with the tire iron, if someone has their hand on the tire iron, but the officer is, I don't know, standing on the tire iron in a position where the person can't use it, they might have the ability, but they lack the opportunity. There's no one vulnerable to that harm. Similar concept with something like this.
I'm just going to go through these frames here. Now they talk about at this point in time, clearly the officer's feet are off the ground, correct?
They are, yes. It looks like he's swinging his right foot over from the position where it was to the other side.
How does that change tactical advantage? Does that change it at all? Does it make it more or less?
I mean, the officer is not in what I would consider to be a particularly stable position. You don't want your weight to just ride on another person because it means that they can take you in a direction you might not want to be taken. But in terms of attack, there's very, very little that Mr. Lyoya could do to threaten the officer in this position. They would have to get out of this position to create a position of opportunity for serious bodily injury or death.
Moving along, you can see the defendant's accessing his firearm at 3356. Has the tactical position changed at all at this point in time?
The officer is in a position of greater stability. Both feet, one knee are on the ground. At least one shoulder or chest area on the left side appears to be on Mr. Lyoya. So there's a less risk of unbalancing here.
Has anything changed in terms of the imminent threat aspect then?
No.
Okay, we're at the 3342. Has anything changed in either part? You're trying to speed ahead. Are there any changes between either of them in terms of the tactical advantage or disadvantage?
I mean,
That's 3440.
3440, I'm sorry.
Again, there's clearly some potential disruption for balance, but in terms of basic positioning, no, not really.
What about now?
No, and no real change.
It's still the same tactical advantage or disadvantage you were talking about.
Yes.
Yeah, I guess I'm not going to go through the whole video. Did you ever see the defendant in any sort of tactical disadvantage through the entire, I guess, cell phone video?
No.
I asked you some questions about committing a felony. He committed resisting opposing, he may have committed a felony. You weren't sure about a Michigan law, but resisting opposing is a felony in Michigan. Does committing a felony allow an officer to use deadly force?
No. In fact, there's a fairly famous line that's often taught in police training. It is not better for all felons to die than to escape.
So no matter how many felonies somebody commits, it doesn't mean that an officer is justified in using deadly force.
That's correct.
What about disobeying commands?
Again, absent an imminent threat of death or great bodily harm, no. Merely disobeying does not establish a justification for deadly force.
So you heard him, you didn't hear him today, but you heard him in the video. Patrick disobeyed, dropped the taser, stopped resisting, disobeyed numerous commands, correct?
Yes, he did.
Does that in any way change your analysis of the ability of an officer to use deadly force?
It's certainly part of the analysis, but no, it does not change the opinion.
Just because he commands them a bunch of times doesn't mean, okay, I can shoot him.
Correct.
they talked about getting into the taser again. You said it's theoretically possible it could be disabling, but you said that it's never happened. The officer's never been killed after being disarmed with his taser in the history of the taser.
That's correct.
Now, you talked about whether the officer has the right to use deadly force after a subject uses or commits a felony, correct?
I don't know that I talked about rights at all.
I think you just answered that question. Does someone have a right to use deadly force simply because they committed a felony?
I would not frame that in terms of rights. I don't think the question had anything to do with does the officer have the right to. As a matter of generally accepted practices, that is not a justification for deadly force.
All right.
But right sounds legal to me, and I'm not testifying on the stand as a legal expert here.
Okay. And you saw the videos. Did Officer Schurr pull his firearm after Mr. Lyoya committed the first felony?
I'm sorry, did he?
Did Officer Schurr pull his firearm by the side of the car?
Very early on. No. I don't think, no.
Okay. And he didn't pull his firearm when Mr. Lyoya refused to obey lawful commands, right?
Yes, at least not initially, yes.
Right, just the last one.
Yes.
And your final opinion about the use of deadly force is based on whether or not it was reasonable for the officer to be in fear based on the fact that whether or not he could be incapacitated. Is that fair?
I wouldn't put it that way. I would say my final opinion is about whether there was an imminent threat of death or great bodily harm.
Okay, and the threat in this case, according to your report, is that he was going to use the taser on him and potentially incapacitate him.
I think that's the argument, right? That's the argument that there was a threat, an imminent threat of death or great bodily harm because of the taser. Again, my opinion is there is no imminent threat. So.